My Lords, thank you. I'm conscious of time, and in the circumstances, if I may, I'll come back to one or two further points in relation to particular statutory provisions. But I do just want to move on and deal with one or two of the points concerned with the reasoning of the Court of Appeal, and in particular, the reliance on the clear words principle. I'll just refer you to the relevant reference. Paragraph 54 of the Court of Appeal's decision, page 162 in the core bundle, it said it relied on a principle that the court will not construe a statutory power to give a direction as extending to giving a direction not to comply with statutory duties under that or another statute in the absence of clear words to that effect. That is the start of the Court of Appeal's reasoning here. I'm not going to go back through the case law we've referred to more generally in relation to the approach to statutory interpretation with which your Lordships will be very familiar, but I do want to pick up the decision of this court in the O case where Lord Hodge, giving the opinion of the majority, and I think on these relevant matters, that also of Lady Arden, dealt with certain issues concerning the clear words principle, or the principle of legality, as it is sometimes referred to, at least in the context of constitutional fundamental rights. So, Authorities Bundle 2, tab 20, please, page 1197. Now, Lord Stevens will be particularly familiar with this case, and I won't go through the background to it, but it concerned questions about the setting of fees for the grant of citizenship and whether or not the secondary legislation permitted fees at certain levels that exceeded relevant costs. If we pick up the judgment of Lord Hodge at page 1208, he starts his analysis having referred to Black Clawson and Spath Home. He then quotes Spath Home, which we have also done in our submissions on the nature of the objective assessment of the meaning which a reasonable legislature as a body would be seeking to convey in using the statutory words which are being considered. He quotes Spath Home in support of that proposition, and we say it's that reasonable legislature test that, applied in this case, makes the outcome of the interpretation we say clear. He then goes on to look at various cases which concerned the principle of legality. He notes in paragraph 33 that the appeal with which the court was concerned didn't concern common law rights or rights which have been recognised as fundamental constitutional nor convention rights under the 1998 Act. He refers then to a series of cases where the principle of legality has been articulated in connection with fundamental or constitutional rights, in particular quoting Lord Hoffman in Sims and more recently my Lord Reid in AXA. He then goes on to consider the principle of legality in the context of the Unison case, and also refers to the fact that you may have special rules of construction where you are dealing with rights of access to the court. So the authorities of Leach and Sims and Daly suggest that particularly clear words may be required in order to limit or abrogate rights of access to the court. He then engages in a discussion or consideration of the Unison case and goes on and looks at JCWI. But if we could go over the page to 1211, it's in relation to the JCWI case where he focuses his particular analysis in this part of the judgment. he was focused there on the judgment of Lord Justice Simon Brown in JCWI concerning the removing of entitlement to certain benefits from asylum seekers and the bleak choice that they were left with in the particular circumstances. It is clear from paragraph 38 that both Lord Justice Simon Brown and indeed Lord Hodge, in analysing the case, were focused on the fundamental nature of the rights that were at issue in that case. Indeed, it is noted that Lord Justice Simon Brown was talking about the extension of the Leach principle concerning fundamental rights being ones that Parliament would not likely abrogate, and in those circumstances clear words were required. And that was in the context where the regulations in question, he considered, would render some of the rights nugatory. If we then go over the page...
I might observe AXA was the same, actually. It's to do, the dictum's to do with incursions into fundamental rights.
Yes. Well, I think this is a theme in relation to these issues. What we see here is actually the court, through Lord Hodge, articulating the importance, and I can skip forward, if I may, to paragraph 43 on page 1213, where he says, where the court is not dealing with an interference by statute with common law constitutional right or with a statutory provision which declares such a fundamental constitutional right, the normal canons of statutory interpretation apply. And there is a quote there from Mr. Justice Laws in Lightfoot about the law being astute to confine the concept of constitutional rights, which in truth everyone living in a democracy under the rule of law ought to enjoy. If the courts were to hold that more marginal claims of rights should enjoy the protection of a rigorous rule of statutory construction not applied in context save that of protection of fundamental rights and freedoms, they'd impermissibly confine the powers of the elected legislature. And we say that is precisely the concern with the use of the clear words rule in the present case by the Court of Appeal, that we're not here dealing with any sort of fundamental or constitutional right. What we're dealing with is a desire on the part of a commercial entity to use a particular piece of equipment. We may, of course, in relation to other instances, not simply be dealing with commercial situations, but the idea that one needs particularly clear words in order to be able to give a direction that licensing is required rather than an exemption from licensing is not something that is required under the principle of legality, or indeed under the other various sorts of well-established presumptions where it is the case that clear words may be used. I've referred already to the access to justice situation. One also sees it in the context of Black. I won't take you to it, but the presumption that the Crown is not bound by a statute unless by express words. And there are various other situations where that may be the case. This is not one of them. Now, what the respondent seeks to do is refer to and rely upon what are referred to cases concerning Henry VIII clauses, and suggest that here we're dealing with powers conferred on the executive to amend primary legislation, and that in those circumstances clear words should be required. Now, there are a number of points that need to be considered here. First of all, in the case law that considers these so-called Henry VIII clauses, in fact, what we see are concerns about abrogation or qualification of what are either fundamental rights or access to justice, particularly in the McKiernan and Public Law Project cases. And therefore, we are much more closely aligned with the more fundamental case law principle of legality type cases than we are with any structural matter. The second point to make is that in relation to the scheme with which we're dealing with a single legislative scheme that has been put in place by Parliament, including in Section 5 of the 2003 Act, the means by which fundamental concerns can be protected. Now, we have referred in our submissions to the case of Cheblak, where the emphasis is placed upon the importance of the protection of national security. Because without the protection of national security, without the protection of and defence of the realm, the discussions one may have about civil liberties, rights, fundamental or otherwise, and the constitutional situation within the United Kingdom become illusory. It is fundamental to the establishment of our rights, of our constitutional freedoms, that we are able to maintain national security and indeed maintain also our broader interests in relation to foreign relations and maintain our international obligations as well. But I do emphasise the national security consideration in this context, because we say, as we have done, that in relation to the mischief with which Section 5 is concerned and the remedy with which it is providing the Secretary of State and the structure within this legislative scheme, we must not lose sight of that importance. And we say the Court of Appeal did do that. When one reads the Court of Appeal's judgment, you do not have any recognition of the importance of the protection of national security or the other interests that are dealt with under Section 5 of the Communications Act.
I suppose you could say also in relation to that, that if one goes back to the EU framework, which the legislation was intended to implement to some degree, perhaps it would be surprising, given that the EU law specifically allows protection for national security, that our domestic legislature would have left that outside the scope of the regime.
Yes, well, I think, yeah, absolutely, although I recognise the respondent would say, yes, but it is protected by way of an exemption scheme.
Right.
But we say there is no reason why you should delimit the way in which the Secretary of State can act to protect national security. That has to be done only proportionately and only where it is necessary. And so it can only be where it is necessary and proportionate to demand a licensing scheme that such a direction can be made. And that, of course, would be consistent with the approach that is adopted under European law as well.
And I wonder whether the point about these measures having to be necessary and proportionate is, to some degree, an answer to the concern of the Court of Appeal that is it really right that a direction can be used to eliminate duties, because the direction will always have to be subject to these EU constraints, and so the scope for elimination of duties is well, perhaps almost non-existent.
Well, I entirely concur with your Lordship's characterisation. Indeed, it's a point taken against us in the written case that look at the breadth of the functions that Ofcom has. If you allow this direction-making power to apply, it could do all sorts of things. It could abolish the numbering plan for telecommunications in the UK. This is all totally fanciful. With the double constraints of the specific heads of public interest that adumbrated in 5.3 and these constraints on necessity and proportionality, the idea that the Secretary of State can go round monkeying with bits and pieces of the telecommunications regulation scheme willy-nilly is just not a tenable submission. And instead, in fact, the concern is that you do have a very wide breadth of Ofcom functions. It is actually difficult to predict exactly where concerns might arise in relation to those functions. For example, I referred, when I was going through the index, to the publicity in relation to the register of notifications given by persons wanting to operate communications networks, and the designation of certain types of networks and services. One can imagine that there could be situations where you actually want to stop Ofcom publicising a notification or a designation. I'm not saying that that is something that would occur, but the idea that one would structure specific intervention provisions for national security concerns in relation to such matters would be bizarre. Instead, what you have is a generalised direction-giving power that is installed in Section 5 that can be used for any of these purposes. And indeed, in that case, you would be in a situation where there is a duty on Ofcom to publicise these matters in the way it sees fit. And if the direction was, no, you really need to keep that secret, then on the face of it, we'd be in the same territory as the Court of Appeal says is impermissible in the present case. And we say that can't be right either. And we do take it at that level. One needs to look, as I say, we referred to the old Hayden's case about focusing on the mischief, the legislation being made in the public interest, and those public interests being of paramount importance in this context. And so we say that cases such as McKiernan Public Law Project, where in McKiernan there are comments by the Master of the Rolls talking about a restrictive approach, albeit, it must be stressed, in the context of access to justice. And also in Public Law Project, do not assist. The third case that's referred to, Cochran, which was to do with the where, when and how of pilot schemes for testing different methods of running elections. There is no indication at all that the approach to the consideration of secondary legislation that could, on the face of it, modify primary legislation required clear words at all. Indeed, we don't see that as good authority for the point. I do take you back briefly, though, to the O case, where, of course, there is treatment by Lord Hodge of similar matters as arose in the JCWI case, I'm so sorry. And if we could just go back to 1212 and paragraph 40. In paragraph 40, there is a consideration by Lord Hodge of the situation where you have a first statute that confers rights and a second statute that comes along and makes modifications through the means of, which provides powers that enables an executive branch of government to make subordinate legislation which impinges upon or even removes rights. And there are two things to emphasise here. First of all, the comments that are made in paragraph 43, the observations in 43 about the limitation on the clear words rule, are made in the context of consideration of this example. Second of all, of course, what is being contemplated here in the context of the JCWI case is that the first statute did give rise to the sorts of rights where their abrogation or attenuation may be of constitutional fundamental importance, such as that the principle of legality is engaged. And of course, the other thing to bear in mind, if we are considering the situation of the reasonable legislator, is that what is being articulated here is two different statutes at different points in time. And of course, that is material in terms of this consideration, because one can see why it is that the courts are slower to be ready to infer that there is a power to modify earlier legislation through subordinate legislation made under the power of the later primary statute, because of the concern that Parliament may not have been alive to the potential for those changes to have occurred, and therefore posing the rhetorical question of the reasonable legislature, did you intend that to happen? It may well be that where you have separated legislation in time, that material affects that question. But going back to our case, if you pose the rhetorical question, what is the answer that the reasonable legislature would give to whether or not here national security, foreign relations, international obligations, public health should enable the Secretary of State to direct that there should not be exemption and there should be licensing, We say the reasonable legislator would say, or the reasonable legislature that we are conjuring would say, yes, absolutely. Given those important values, that is precisely what we consider as important here. Now, there's one other case I do need to pick up in relation to clear words rule, which is the EE case, which was specifically relied upon by the Court of Appeal in this context as an example of the clear words principle. If we could just pick it up, it's in the Authorities Bundle, tab 17, page 1143. So this was a case, again, concerning telecommunications, indeed concerning the same two acts with which we are concerned. And indeed, one of the phrases that is at issue in this case is the power that is given actually under the Wireless Telegraphy Act 2006 about the ability of the Secretary of State to give directions to Ofcom about the carrying out by them of their radio spectrum functions. But I should stress it is in a different section in the WTA 2006 from that which we've been referring to, and it's obviously not focused on Section 5 of the Communications Act. It is nonetheless extremely confusing to read just because of the similarity of the provisions that we're talking about. In any event, what had happened in this case was that there were powers conferred upon Ofcom to set fees in relation to spectrum through the auctioning process. And the Secretary of State had used his directions power essentially to tell Ofcom how to set those fees. And the question then became one of interpretation, but as part of the interpretive exercise, the court considered whether or not the Secretary of State should be held to have virees to make such a direction, because if it didn't have virees, that would affect the way in which the interpretation worked. And the conclusion was that the Secretary of State didn't have the relevant virees to make such an order requiring Ofcom to set prices in a particular, set fees in a particular way, and that had it been intended that the Secretary of State's direction-giving power was going to be such as to enable that, it would have been by clear words, was the conclusion of the court. But it is worth just emphasising that in the consideration of this matter, it appears, first of all, from the judgment that none of the relevant cases in relation to the clear words principle were referred to. And indeed, so far as we can see, only one, the Unison case, was actually referred to in the course of argument. The clear words principle was clearly not at the heart of this consideration. And one can in fact see that in the section concerning virees, which begins at 1162. And if one goes over the page to 1163, you can see the question that Lord Justice Patten was posing to the court. The general principle is not in dispute, and the question of virees really turns on Section 5 of the WTA. Does it empower the Secretary of State to repatriate to himself the function of setting licence fees in accordance with Article 8?
I'm so sorry, where are you reading?
Paragraph 52, I'm so sorry, my Lord.
Sorry, I missed it.
No, I'm sorry, I'm going a little quickly, I recognise.
Yes, thank you, I had it.
That is actually Article 8 of the European provisions rather than any domestic. And if so, did the 2010 direction have this effect? And then you'll see 53, Section 5 of the WTA 2006 allows the Secretary of State to give directions about the carrying out of radio spectrum functions. These include the power to set licence fees, so the functions include those. And although Section 5.3 allows a direction to require Ofcom to exercise its powers in such a manner as the Secretary of State specifies, what it does not do is transfer to the Secretary of State the function of exercising the Section 12 power, which was the fee-setting power. Now, the advocate for EE, Lord Panic, submitted that the Secretary of State had purported to do so, that had it purported to do so, that would have been a breach of the provisions of the CRF, so the Common Regulatory Framework, in particular Articles 3 and 3A of the Framework Directive, which require member states to guarantee the impartiality of the national regulatory authorities. So the case that was actually put was, if you allowed this, it would be in breach of European law. But Lord Justice Patten decided the case differently. It's not necessary to resort to EU law. The power to give decisions is in respect of the exercise of Ofcom of its radio spectrum functions. The Secretary of State was not thereby empowered to exercise those functions himself, nor did he purport to give himself that power by the 2010 direction. It's phrased in terms of requiring Ofcom to exercise its powers so as to implement the package of reforms, including directing Ofcom to raise the licence fees. So he then poses this question to himself about the interpretation of the language, and over the page he concludes, halfway down the first paragraph, in the absence of clear words, the Section 4.2 duty is to be treated as non-delegable, and there's nothing in Section 5 of the 2006 Act which in terms allows the Secretary of State to relieve Ofcom of the statutory duties which Parliament has expressly imposed on it. For these reasons I did then go on and interpret the relevant other provisions. Now, the Court of Appeal relied on this as a good example of the clear words principle in action. We say, in the light of O and the reasoning of Lord Hodge, there must be reason to doubt that this approach to the clear words principle is in any event correct. But it's more than that here, because what was being done by the direction in this case was essentially repatriating, in Lord Justice Patten's words, repatriating the fee-making power to the Secretary of State, one that had been given as a whole to Ofcom. Now, what the equivalent in our case would be the Secretary of State trying to use the direction giving power under 5.2 of the Communications Act essentially to say, I'll make the assessment of undue interference. In other words, the statutory scheme had specifically given that part of the assessment to Ofcom, but the Secretary of State fancied having it back. Now, we say that that means that even if you can find a basis for a clear words principle to operate here, and we say that is doubtful in the light of O because you're not dealing with any sorts of fundamental constitutional rights, that in any event it would fit into the category of something that was semi-constitutional because you're talking about a delegation of functions.
Although Lord Justice Patten says in paragraph 53 that it's not necessary to resort to EU law, he does emphasise the EU origin or basis of Section 4.
Yes, he does.
In paragraph 54.
He does.
So I think that may have some relevance, really, to his analysis.
It may well do. I mean, the analysis is not, as I say, the analysis here is not absolutely clear because, of course, there is no consideration of any case law in relation to when the clear words principle should apply. And so it looks like what was argued was a European law point. Lord Justice Patten appears to have thought there may be other things against the context, against the backdrop of the European law submissions, but quite how that interpretation of Section 4 fits into the ratio of his decision, I think, is not perhaps something I can...
I mean, I rather read it as him referring, as my lord says, to EU law, not so much on a mar-leasing type interpretation, but to show it's an important feature of the EU regime that fee setting be by an impartial body.
Yes.
That shows that when one comes to construe the domestic statute, that must be taken to be, if you like, a fixed point within the statute, incapable of being removed or repatriated by some direction from Ofcom, because it's a fundamental aspect of the regime in order to secure compliance with EU law.
Well, I completely see your Lordship's reading of that, and that would fit with the submission that was actually being made by Lord Pannick, albeit Lord Pannick was saying you don't need to go to the domestic law, you can just do it on a European law basis. But the two things would then fit together, because what you are saying at that point is that by dint of the scheme of European law, this is a fundamental issue. As Lord Pannick appears to have been putting it, it's about the impartiality of the national regulatory authorities in setting fees.
I mean, it does occur to me that the very model that Lord Justice Patten is using, and you've emphasised, I think it's from paragraph 52, the idea of repatriation of functions, almost presupposes that he's accepting that within the statutory regime there is a division of functions which are covered. Yeah. It's just that this particular one isn't capable of exercise by Ofcom. Exactly, and I therefore don't have any issue with that, given the submissions we're making in relation. I was rather putting to you that actually it could be. It's a glancing way of putting it. Very much accept that, but and adopt it. Could be taken to support you. I think that does. But I also recognise the point that you're dealing with a different scheme here as well, because you're dealing with the fee setting having been adopted through the European scheme in those circumstances, whereas of course that is entirely different in relation to Section 5. So
it didn't really strike me this morning when you were taking us through the history, but it's striking me now that under the 1949 Act, in its original form, the Section 1 power was vested in the Secretary of State.
Yes.
And the minute it's given to Ofcom in 2003, and we have the Section 1AA exemption, which places a duty on Ofcom, at that very moment we also have the 2003 Act kicking in, which imposes duties on Ofcom. Well, the Section 3 duties probably aren't relevant, since there is a specific statutory duty on Ofcom under Section 1AA. But Section 5 then comes into force, which brings in the directive power of the Secretary of State, which one might view as maintaining in the hands of the Secretary of State the responsibility for national security and so forth that previously went without saying when he held the power under Section 1 of the 1949 Act.
We make precisely that point in relation to the context issue on history. In our written case, it's in paragraphs 38 to 41 in particular. Indeed, what we emphasise is that there is no basis for assuming that the reasonable regulator, having had a situation prior to the Communications Act 2003 where the Secretary of State was the competent person and therefore could control matters by reference to national security and ensure licensing, is suddenly flung out of that process without any language being used. Indeed, we note that in fact there are certain cases which suggest that there should be a presumption in the other direction. You shouldn't lightly remove from a government body important functions that it retained by implication when legislation is changed. And we say, insofar as any presumption is relevant, that might be it. But we don't need to get into presumption territory here. We say just look at the context. The context is important values were previously capable of protection through the licensing regime, no longer on the Court of Appeals case have to fall back on an exemption regime.
Now, I should say, Mr. Beard, that one way or another, you lost about 45 minutes this morning. Yes. So if you can wind up by past, that'll give you your appropriate time, and Mr. Segan will then be able to get cracking.
Yes, that's what I was targeting, and I'm sorry if I was going a little through some of the case law, but that's exactly where I'm headed in relation to this. So if we look at our overall positive case in relation to why our interpretation is correct, first we say critical public interests that Parliament clearly wanted to protect national security important amongst them. The idea that Parliament was saying you can't have licensing to protect those things, you must have exemptions and then be creative with conditions. We say that is not the right approach. We say that you do not need to apply a clear words, an absence of clear words approach. Indeed, that is the wrong approach to this. You simply look at ordinary statutory interpretation principles. In thinking about these matters, it is right to bear in mind that what you have is a single scheme that was being put in place in 2003, where the Secretary of State had the role in relation to areas where he had particular expertise, and Ofcom had its role in relation to its areas of particular expertise. The further point is the fact that the idea that Parliament was taking away, effectively, the power of the Secretary of State to protect national security through prior licensing regimes is flawed. Going back to the points that were raised just before the short adjournment about the existence of a lacuna, it's worth just bearing in mind the significance or otherwise of this point. All that is being said by the Secretary of State is Parliament would have intended that we could require a licensing regime, not an exemption regime for particular pieces of equipment, and that a lacuna could arise if the operation of equipment under an exemption could jeopardise national security, foreign relations, international obligations, even if conditions were placed on that exemption, because you wouldn't have the prior control. As to the evidence in relation to those matters, it wasn't a generalised evidential matter that was put forward in relation to that. It was simply said that is an issue that should be taken into account in relation to statutory interpretation. But then it did go further because, of course, in relation to this case, Mrs. Justice Rose said that the requirement for licensing, in other words, the commercial use restriction, was not equally effective as other solutions. In other words, it was proportionate to have that licensing solution, even though it would be more intrusive than having an exemption regime. And those are the conclusions she reaches on proportionality. I just give you the reference, but it's in her confidential annex, in particular at A26, page 1489, at paragraph 30. Now, in the first instance judgment, Mr. Justice Morris, at paragraph 81, so that's page 198 in the core bundle, in Appendix 1, asserted that there could be no lacuna. But of course, on a judicial review, it was unclear on what basis Mr. Justice Morris felt he could make that assertion. He did have before him the material from the witnesses that I showed you before the short adjournment. But the key point here is that what we're doing is asking ourselves, what would the reasonable legislator have done? Would it have precluded the Secretary of State being able to do these things? We say not. And just to deal with the Jay and Welsh ministers case that is referred to, this isn't a situation where we're trying to reverse into a power by reference to a purpose. In Welsh ministers, you had a situation where what was being asked was whether or not there could be a community treatment order imposing all sorts of restrictions on liberty, simply on the basis that it was less restrictive than a hospital detention order. And obviously, there are a whole range of considerations to do with liberty and the nature of the powers conferred, which meant that in that case it was said you couldn't assume that it was useful to have conditions in a community treatment order and then say, well, that must mean that the power provided for them. So it's not a cart before the horse case.
And just on the lacuna point,
yes.
I mean, I can see it potentially has some relevance, but I mean, if you get away from the clear words principle, according to your submissions, then almost the question becomes, why would Parliament not have intended the Secretary of State to have a ex-ante licensing power to control matters as well as an ex-post exemption power?
Yes.
even if you could meet things by the ex post exemption power, it may be that Parliament intended the Secretary of State to have a number of arrows in his quiver to deal with the thing, rather than necessarily treating them as exclusive.
Well, absolutely, because you can't predict, obviously, particularly in telecoms world, where technology is constantly changing, you can't predict what you're going to want to be able to do. And of course, this also is allied to the constraints on those powers, necessary and proportionate. So if it turns out that it is not necessary and proportionate to have a licensing regime and an exemption scheme with conditions is sufficient, then the Secretary of State doesn't actually have the ability to impose the licensing regime at that point. He doesn't have the power to make the direction. So absolutely, it's giving the ability to build the arrows. It's not necessarily saying what targets you can fire them at or when. Why would Parliament, as my Lord rightly puts it rhetorically, why would Parliament not provide the Secretary of State with that ability? I need to pick up just a couple of linguistic points. Obviously, one of the points that's made against us by reference to Section 5 is carry out functions can't mean not carry out functions, and what you're doing here is requiring Ofcom not to carry out its functions. Well, we say, no. Functions are a broad category here. We've seen that when we look at the early provisions. The functions we're talking about here are spectrum management functions. If one wants to go to a narrower, more granular description, you can talk about licensing and exemption from licensing functions. The language of carry out is perfectly amenable to the interpretation that we put forward. And indeed, that language, of course, is being used in relation to a whole range of functions where national security directions might be given, whether general or specific. And in those circumstances, the language of carry out is perfectly appropriate as a compendious term to deal with all of the situations that might arise in circumstances where you can't anticipate them. Freighting the words carry out with the sort of heavy interpretive burden that the respondent of the Court of Appeal sought to do is simply not correct. There are references to other provisions, both in the Communications Act and in relation to other legislation, and we better just turn one of those up. It's Section 154, which is at Authorities Bundle A 5978. Now, you'll see in 154 that there is a range of duties of Ofcom when carrying out the spectrum functions. We know that spectrum functions may be wide. And you'll see in 1, it's a have regard duty to the various points. Same in 2. Have regard duty to the desirability of promoting. 3. It's slightly different, but nonetheless is not imposing strict duties. And then 4, which is the provision that's heavily relied upon, where it appears to Ofcom that any of their duties under this section conflict with one or more of their duties under sections 3 to 6, priority must be given to their duties under those sections. So what it's being said here is that if one goes back to the general duties that we looked at the beginning, what's being said here is that those general duties, many of which are have regard duties, are to be given priority over these have regard duties. Now, it is also true that by referring to sections 3 to 6, it is covering section 5 and directions that could be made under section 5. We completely accept that. But the fact that section 5 is referred to in this compendious term 3 to 6 doesn't mean that somehow you should impliedly constrain your interpretation of section 5, 2 and 3 and somehow say that it was necessary for the direction giving power under 5.2 to have been explicitly stated to act as a trump in relation to other obligations, we say it is clear from the proper interpretation of the context and purpose of Section 5 itself that it enabled the Secretary of State to give directions that modified the way in which Ofcom operated in narrow circumstances under 5.3, and it doesn't therefore give rise to a conflict. I use the term conditioned Ofcom's duties or mode of operation earlier. I'm not wedded to the particular term, but the point is it is not right to see it as a conflict. It is a scheme whereby, in certain circumstances, the Secretary of State can modify what Ofcom would otherwise be doing. The other provision that is referred...
I'm going to have to bring you to a close, Mr. Beard, I'm afraid.
Yeah, understood.
We really need to hear Mr. Segan.
I'm grateful. The only other provision I was going to refer to was Section 94. It's in another act, and the same point applies in relation to that.
We're aware of Section 94, and obviously we have your written submission.
I'm most grateful. Thank you.
Thank you very much, Mr. Beard. I'm sorry to bring you to
No, it's absolutely fine. I recognise I'm trespassing on Mr. Segan's territory.
Yes, I'm afraid so. Mr. Segan.
My Lord.
Mr. Segan, I should say that... Are we able to go on beyond 4?
I am, yes.
Yes, if you need to, we can go on beyond 4 o'clock.
I'm most grateful. I shall see how I get on.
Yeah.
My Lords, it's worth stressing at the outset that the only issue that arises in this appeal is a pure point of law. It's a pure question of vires as to whether the Secretary of State had power under Section 5 of the 2003 Act to direct Ofcom not to comply with its duty under Section 8, subsection 4 of the 2006 Act. Now, in that connection, naturally, Mr. Beard has emphasised to you the importance of national security and of the role of the executive in preserving and promoting it. My client, for its part, has never taken issue with those propositions, and nor did the High Court and nor did the Court of Appeal. My client accepts and has accepted throughout these proceedings that substantive judgments on national security matters are a matter for the government, acting in accordance with the powers conferred by Parliament. And those qualifying words are, of course, crucial. It's a point which is made, indeed, by Lord Donaldson, Master of the Rolls, in the ex parte Cheblak case, which is relied upon by my learned friend in relation to the importance of national security. And it's worth just turning up very briefly the relevant passage. It's in Core Authorities, Volume 2, tab 24, and at page 907 of the report, electronic page 1374, in between letter C and D, Lord Donaldson says, in the case of national security, so this is page electronic 1374, between C and D. In the case of national security, the responsibility is exclusively that of the government of the day, but its powers are limited by statute, and the courts will intervene if it is shown that the minister responsible has acted otherwise than in good faith, or has in any way overstepped the limitations upon his authority which are imposed by the law. And in this case, the High Court and the Court of Appeal both held, we say rightly, that when the Minister of State made the direction in September 2017, to use Lord Donaldson's words, he overstepped the limitations upon his authority which are imposed by the law. And in that regard, the legal issue that arises here is a stark one. It is stark because the direction was, in terms, squarely contrary to the duty imposed upon Ofcom by Section 8, subsection 4 of the Wireless Telegraphy Act 2006. Section 8.4, which is a provision of primary legislation, imposed a clear duty to exempt. It says Ofcom must make regulations exempting, and we'll come to that. The direction given by the minister, by contrast, instructed Ofcom to do the precise opposite. It says, shall not be exempted.
So can I ask, is there any context in which the power in section 5.2 could be used in respect of the licensing duty under section 8.4, or do you just say that's something which is untouchable by the section 5.2?
It can be used to direct Ofcom as to the conditions, restrictions, limitations and the such like that can be imposed upon the exemption that's required by the legislation.
But why, if such a direction is given, isn't that in conflict with the duty of Ofcom? Since Ofcom, if they weren't subject to a direction, would be under a duty to grant licensing according to restrictions which it thought were necessary for its purposes.
Because Ofcom would be exempting and the Secretary of State would be directing Ofcom in relation to the carrying out of that exemption, which is required by the statute. So that's in accordance with the power in section 5.
Well, I think that's what I'm pressing you on. Where is the distinction between a direction as to the carrying out of the duty and a conflict with the duty? Isn't any direction as to the carrying out of the duty, to that extent, a conflict with the duty?
No, because it's a duty to make regulations exempting. Now, at that point, then the Secretary of State has the right to direct Ofcom in relation to how, in other words, that duty is carried out. What it can't do, and the reason I emphasise the starkness of the conflict, what it can't do, consistently with the words of the statute, is direct Ofcom not to make regulations at all. The duty is to make regulations exempting, and the direction says the exact opposite. And we say the lower courts, the High Court and the Court of Appeal, were quite right to find that nothing in Section 5, nothing in the Wireless Telegraphy Act 2006 indicates that such a power has been conferred. Now, the Minister was presented, according to the witness evidence, which we'll be looking at later, with a range of options to address the CLI issue, only one of which was the making of a direction of the kind ultimately made. And we say amongst the range of options he was presented with, he chose an option which exceeded his powers. And in developing that case and responding to the submissions on behalf of the Secretary of State, I'm going to be developing 3 principal points. The first is that the primary source by which meaning is to be ascertained here is the words used by Parliament, having regard, of course, to their context and purpose. And we say that in that regard, when the executive is claiming a power to override what would otherwise be a mandatory effect of primary legislation, clear words must be shown, or else a necessary implication, general words don't suffice. That's the first point. The second principal point I'm going to be making is that whichever approach to statutory interpretation is adopted, be it the restrictive or the ordinary one, the words used by Parliament in the Wireless Telegraphy Act 2006 and the Communications Act 2003 simply don't support the submission that a Section 5 direction is capable of overriding Section 8, subsection 4. So that's the second point I'm going to be developing. The third is that nothing in the context or purpose of the 2 statutes in issue leads to any other conclusion. Indeed, on a proper analysis, the Secretary of State's argument would render a large swathe of primary legislation liable to being overridden by a ministerial direction, which is not even required to be laid before Parliament, let alone approved by it. And in the course of developing those 3 points, I'll of course pick up and address the various submissions made by my learned friend. So turning to the first of those 3 submissions, the primary source by which meaning is to be ascertained is the words used by Parliament. Well, I've addressed the principles of interpretation at paragraphs 31 to 37 of my written case. The primacy of the words used by Parliament has been stressed by the courts on numerous occasions. I can pick it up, for instance, in the O case, which we've already looked at, in Authorities Core Volume 2, tab 20, page 1201 is the start of Lord Hodge's judgment, and the paragraph I wanted to take your lordships to is at page 1207, electronic. Paragraph 29. The courts, in conducting statutory interpretation, are seeking the meaning of the words which Parliament used. There's then reference to Lord Nichols. Statutory interpretation is an exercise which requires the court to identify the meaning borne by the words in question in the particular context. Words and passages in a statute derive their meaning from their context. A phrase or passage must be read in the context of the section as a whole and in the wider context of the relevant group of sections. Other provisions in a statute and the statute as a whole may provide the relevant context. They are the words which Parliament has chosen to enact as an expression of the purpose of the legislation and are therefore the primary source by which meaning is ascertained. While I'm in this authority, could I also take the court to a passage which my learned friend took you to, at page 1212. In paragraph 41, describing the exercise of determining whether one statute has enabled a right conferred by another statute to be abrogated, Lord Hodge says, in performing that interpretative task, the court has regard to well-established prima facie assumptions. It is an aspect of the principle of legality that Parliament is assumed to take for granted long-standing... I'm so sorry, Lord Lloyd-Jones...
The page again, please.
Indeed. Electronic page 1212, my lord.
Thank you.
And in paragraph 41, Parliament is assumed to take for granted long-standing principles of constitutional and administrative law, and a statute is to be interpreted accordingly. And then further on, these and other assumptions or presumptions are part of the tools used by the courts in the interpretation of statutes. So there's reference to assumptions and presumptions.
Well, the next sentence is relevant. The weight to be attached to such presumptions will vary depending upon the circumstance of the case and the nature of the rights affected by the legislation under consideration. And the nature of the rights affected here are not one-sided. It's a comparative exercise. It is a right to use a particular bit of equipment on the one hand and national security on the other. And so the weight to be attached to a presumption of clear words will vary depending upon the nature of the rights affected by the legislation under consideration.
Well, my lord anticipates the point that my learned friend has been making about whether trespassing on fundamental rights is sufficient.
The most fundamental right here is national security. Wouldn't that be correct? The most fundamental matter, sorry.
Well, I'm not sure I would necessarily always give normative or presumptive importance to one particular...
The most fundamental right, then, is a proportionate and necessary interference to support national security.
Well, my lord, naturally, and as I hope I emphasised at the start, it's no part of our case to dispute the importance attached to national security. The only question here is whether the means by which the Minister in September 2017 chose to give effect to his concerns in that regard were lawful or not. And my lord, in relation to the importance of the text, the observations from O were cited with approval in the Cochrane case, decided in April this year. I don't need to take you to it. It's paragraph 13.
And page number is
and the electronic page number is 1125. We also have in the bundle a collection of citations for the same point from Bennion, which is Authorities 2, tab 30, electronic, page 1640, and it's headed The Importance of the Text. And indeed, the text remains the primary source even when one is ascertaining the context or the purpose of the legislation, and that's a point from the SC case, cited in paragraph 32 of our written case. And again, I don't need to take the court to it, but in paragraph 32 of SC, which is Court Authorities, Volume 2, tab 28, my Lord Reid, for the 7-judge Supreme Court, holds that Parliament's intention is ascertained primarily from the language which it has used.
And I'm so sorry, do you have a page number for that? Don't take up time. We'll find
I'm most grateful, my Lord. One of the established presumptions or assumptions, to use Lord Hodges' words from O, which is applied in the interpretation of legislation, is that Parliament does not lightly delegate to the executive the power to modify or override primary legislation. I addressed this point at paragraphs 33 to 37 of my written case. The presumption can be seen in operation in the authorities on so-called Henry VIII powers.
But you say there's a modification of primary legislation happening in this case?
Well, what I'm going to come to, my Lords, is that the essential submission on this is that there is no material difference between a statutory instrument which purports to amend a piece of primary legislation and a statutory instrument, or in this case a direction, which purports to override a piece of primary legislation, particularly where the duty which is being overridden is a duty to make an alteration to the general law of the land. The duty in section 8, subsection 4, is a duty to make regulations. It's not to take an action in a particular case concerned with a particular person. Parliament has said that if the conditions in section 8 are met, Ofcom must alter the law of the land in a particular way. And by overriding that duty, the Secretary of State in this case was doing something which is either materially identical or akin to modifying the relevant primary legislation.
But on one view, it's just giving effect to the power conferred on the Secretary of State.
Well, my Lord, obviously,
by effectively the same legislation. It's not modifying Section 8, it's just saying that in this case that duty is overridden by the Secretary of State's direction, which is what Section 5 provides.
So this is...
So that may take you to the looking at the terms of Section 5, but I don't really understand why there's any amendment of Section 8 going on here.
But one always... Obviously, I accept that one is not speaking about actually modifying or amending Section 8. Nobody is doing that. But what is occurring is Section 8 is being overridden.
But pursuant to a power that specifically says you can override it on
my Lord,
the argument against you.
That's the question. And in my submission, when one is approaching those questions as to whether one power permits another duty or another piece of primary legislation to be overridden, the presumption that's applied by the courts, and we'll see this in the Public Law Project case, is that Parliament doesn't lightly delegate that sort of power, and insofar as there is any doubt, that is to be resolved against the person claiming the power.
But that's just a presumption, and the strength of it depends upon the circumstances of the individual case. The appellant contends that it only comes into play when there are fundamental rights in issue, but it's not necessary to go that far as the appellant is concerned, because they can say the nature of these rights aren't of fundamental importance in comparison to the fundamental importance of national security.
Well, my Lord, let me pick that up in the Public Law Project case, but let me foreshadow what the answer to it that I advance is. We're not here in principle of legality territory concerned with fundamental rights. The presumption identified in the Public Law Project case and that applies in relation to Henry VIII powers arises not because of the character of any underlying rights of any individual, but rather because of the constitutional status of primary legislation. And we can see that from the Public Law Project case, which is in Core Authorities, Volume 2, Tab 22.
But all we need really is the electronic page, because we only have electronic bundles.
At electronic page 1285, this is in the judgment of Lord Neuberger, with which the other 6 members of the court agreed. At paragraph 20 at the bottom, Lord Neuberger says the draft order, once formally made, would of course be secondary or subordinate legislation, unlike LASPO itself, which as a statute is primary legislation. If there's any description of primary legislation being initiated by a bill placed before Parliament, and the point that Lord Neuberger makes is in relation to the extent of scrutiny and debate in relation to primary legislation. Paragraph 21. Subordinate legislation consists of legislation made by members of the executive, often as in this case by government ministers, almost always pursuant to an authority given by Parliament in primary legislation. So the issue is always about the construction of the enabling power. The draft order in the present case would be a statutory instrument, which is a type of subordinate legislation which must be laid in draft before Parliament. And then there's reference to the negative resolution procedure and the affirmative resolution procedure. And what underlines the concern emerges from paragraph 22. Although they can be said to have been approved by Parliament, draft statutory instruments, even those subject to the affirmative resolution procedure, are not subject to the same legislative scrutiny as bills. And unlike bills, they cannot be amended by Parliament. And then there's reference to Hoffmann-La Roche. Paragraph 23, there's reference to subordinate legislation being held to be invalid if it has an effect or is for a purpose which is ultra vires. Third line, in declaring subordinate legislation to be invalid in such a case, the court is upholding the supremacy of Parliament over the executive. That is because the court is preventing a member of the executive from making an order which is outside the scope of the power which Parliament has given him or her by means of the statute concerned. Accordingly, when, as in this case, it is contended that actual or intended subordinate legislation is ultra vires, it is necessary for a court to determine the scope of the statutorily conferred power to make that legislation. So the question is, what's the scope of the power that's being conferred? Normally, statutory provisions which provide for subordinate legislation are concerned with subsidiary issues such as procedural rules, practice directions, etc. However, such statutory provisions sometimes permit more substantive issues to be covered by subordinate legislation, and as is the case with Section 9(2)b, they sometimes permit subordinate legislation which actually amends the statute concerned, or even another statute, by addition, deletion, or variation. Lord Neuberger then goes on to Henry VIII powers, and in the fourth line of paragraph 25, when a court is considering the validity of a statutory instrument made under a Henry VIII power, its role in upholding parliamentary supremacy is particularly striking, as the statutory instrument will be purporting to vary primary legislation passed into law by Parliament. So the concern in my submission that emerges from this passage relates to the normative status of the two types of legislation in issue. The concern is that a statutory instrument should not, without clear words or by necessary implication, be capable of having the effect of varying primary legislation. 26. The interpretation of the statutory provision conferring a power to make secondary legislation is, of course, to be effected in accordance with normal principles of statutory construction. However, in the case of an amendment that is permitted under a Henry VIII power, to quote again from Craze, as with all delegated powers, the only rule for construction is to test each proposed exercise by reference to whether or not it is within the class of action that Parliament must have contemplated when delegating. That's the general test. Although Henry VIII powers are often cast in very wide terms, the more general the words used by Parliament to delegate a power, the more likely it is that an exercise within the literal meaning of the words will nevertheless be outside the legislature's contemplation. The concern is, has Parliament actually contemplated or confronted the proposed exercise of the power in any given case? And then in paragraph 27, there is a further approval of Lord Donaldson's dictum in McKiernan, whether subject to the negative or affirmative resolution procedure, subordinate legislation is subject to much briefer, if any, examination by Parliament and cannot be amended. So again, the concern is with a lack of scrutiny and a lack of any ability to amend. The duty of the courts being to give effect to the will of Parliament, it is, in my judgment, legitimate to take account of the fact that, and this is the presumption, a delegation to the executive of power to modify primary legislation must be an exceptional course. And that if there is any doubt about the scope of the power conferred upon the executive or upon whether it has been exercised, it should be resolved by a restrictive approach.
Could I ask you this? Under either the 2003 Act or the 2006 Act, are there any express powers conferred on the executive to amend primary legislation?
I've been through, as my Lord can probably imagine, all of the powers to make delegated legislation that appear in the passages that are in our bundles. And I think I can say with confidence that there is not.
Not of those in our bundles, but I was asking more generally.
The reason I caveat it in that way is that I haven't exhaustively read part 3, sorry, is it part 3 or part 4 in relation to broadcasting, so I can't say categorically that there isn't such a power in there.
Yeah.
There are powers to modify particular, well, actually, I think the answer I've just given to my Lord is wrong, and the reason for that is this. If one goes to the Communications Act, there are powers to amend things like penalties, which are provided for in primary legislation, and in every case, the requirement is that those pieces of secondary legislation be laid before Parliament.
Well, that would suggest that Parliament didn't think that the Section 5 power was an amending of primary legislation.
Correct, which in my submission is consistent with my case, because one has a statute here where there are...
So I come back to the point as to whether there's any amending of legislation going on here, because that seems to be a significant part of your submissions, and you just referred us to Lord Newberger addressing those very issues. But my concern is whether that's really relevant to what we have in this case.
I think I come back, my Lord, to the point that I made earlier, which is that I accept that we're not talking here about actually amending Section 8. The direction does not purport to do that. So this is not a Henry VIII case, stricto sensu. I accept that. I accepted that below.
But you're saying that they're analogous?
Highly analogous, my Lord. And the reason for that is that the effect of the direction in this case, if lawful, would be entirely to reverse that which a piece of primary legislation specifically requires.
That just depends on the proper construction of the Section 5 power. It takes you just back to the language of the Section 5 power. It doesn't engage some general principle of statutory construction.
My Lord, in my submission, what it entitles the court to do is apply an approach when asking that question. I accept and agree that that's the question. But to apply an approach when asking that question, which says that any doubt in that regard is to be resolved against a person claiming a power to override a statute.
Why?
Because of all of the policy concerns identified by the...
The question is, what did Parliament intend to confer by the Section 5.2 power?
Yes.
Not what are the safeguards necessary to amend primary legislation.
My Lord, the question in every case where one is asking, has Statute A conferred a power to amend, or as I would have it, override Statute B?
Well, technically it's Statute A and B, but these two statutes are clearly intended to be read together, aren't they? In fact, I think it says so.
Oh, they form their statutes.
It doesn't matter.
Yeah, yeah.
Your point is the same if they were actually contained in the same.
Yes, quite. So the provision A and provision B.
Yes.
The question is always, has provision A conferred the power to vary or, on my case, override provision B?
Disapply the duty, if you like.
And the Public Law Project makes quite clear that that question is to be answered in accordance with ordinary principles of statutory construction. We saw that a moment ago. But it makes clear that where that question is, has provision A conferred a power to override provision B or to vary it or modify it, a restrictive approach applies.
Could I ask you just a slightly different question? I mean, you've shown us this passage from McKeon, which emphasises, if you like, the importance of the procedural way in which primary legislation is passed, and then contrast that with the passage of subordinate legislation. But might it not be the case that in some contexts there are good reasons for not using ordinary parliamentary procedures? And it strikes me that when dealing with national security in this context, two factors might be important. The need for things to be done at speed, which is not always something which can be achieved within Parliament. And secondly, the need for things to be done on the basis of secret confidential information, which may be available to the Secretary of State, but by reason of its national security implications cannot be readily placed before Parliament and debated.
My Lord, I wouldn't dispute that either of those are possible considerations. I accept that. But in my submission, they are also factors which tend in favour of an approach which asks, are there clear words here permitting this? Because your Lordship posits to me very fairly that this is national security, there may be a need for confidentiality, but we're talking therefore about the confidential suspension of a statute. Now, that, in my submission, if there is power to do that, that needs to be conferred clearly.
But I mean, in some contexts, one has provisions expressed in general terms precisely because Parliament intends it to operate in general terms. I mean, this is part of the argument against you, that Ofcom has many and varied duties across the whole scope of telecommunications, and issues of national security might arise in unforeseeable ways across any of that terrain. Might it not be a reasonable legislative response to that, to deal with that sort of problem, that instead of having highly particularised powers of disapplication or however you want to describe it, of the statutory duties, that one would have a general power, in effect, to disapply the duties as and when the problems are seen to arise? In other words, you're making a point on the generality of the language in Section 5.2, and what I'm putting to you is that there may be some contexts in which the proper inference from the use of a generally phrased provision is precisely that Parliament did intend it to be general.
My Lord asked whether that might be a reasonable response of a legislature. I don't dispute that at all. It might be. The breadth of the functions to which this power applies, however, is an additional factor which warrants very careful scrutiny as to whether that power has actually been conferred. And we will come to this, but the Section 5 direction power applies to the whole of Part 2 of the 2003 Act, and, because of Section 5(1)(b), to what were, at the time of the enactment of the statute, 5 other statutes. And my learned friend makes no submission that there is anything in the Section 8 duty that makes it particularly susceptible to being overridden by a Section 5 direction. So his case on its face means that the duties, all the other duties of Ofcom, under all of that large swathe of primary legislation, are also liable to being overridden by a direction under Section 5.
But I'm sorry to pick you up on this. I thought you accepted that the Section 8(4) duty is capable of being overridden to some extent.
No.
Oh, right. Sorry, I misunderstood your earlier answers to me.
My Lord, if I seemed to accept that, that was certainly not the way I intended to answer your Lordship's question. The duty is to make regulations exempting. My submission is that the Section 5 direction power permits the Secretary of State to give directions in relation to the carrying out of that duty. Insofar as that duty is being carried out, it is permissible to give directions. But what the directions cannot do is give a direction that amounts to a direction not to carry out the duty. So, and it may be that it's a different conception of what amounts to overriding, and I have, if I wasn't clear about that, then I apologise. But certainly, my submission is that overriding occurs at the point at which the direction is no longer in relation to the carrying out of the duty. And in this case, we are not at the margins, not remotely at the margins, because the direction is squarely one to override. But I do submit that what one gets out of Public Law Project is that this is not a principle that emerges from concerns about fundamental rights. It's a concern that emerges from concerns about the relative or normative status of subordinate legislation and primary legislation.
It does arise in a completely, well, what strikes me as an exceptional factual context. We're talking about an industry where there is a huge commercial value attached to privacy of communications, and where there is a national security imperative to maintain the possibility of interception of communications and surveillance of communications. And the minute somebody in the market provides a means of communicating which is immune from surveillance or interception, he's found the end of the rainbow commercially, but it's also immediately extraordinarily dangerous. from the point of view of the rest of us, because of the scope for it being used to plan terrorist attacks or whatever you can imagine. And so it's a context where if Parliament has created a framework of duties upon a regulatory authority, there just isn't going to be time to respond to that kind of development by means of primary legislation. And one can understand in that context the need for the ability to respond at once. And I mean, obviously this case illustrates the point, because it's all about something as simple as making a call from a landline to a mobile phone being immune from surveillance.
My Lord, I think it makes 2 points to me. The first about anonymity and its desirability, and the second about speed of response. In relation to the desirability of anonymity, my Lord's quite right. This was, and I'm in open court, so I cannot go into too much detail, but suffice it to say in general terms that the court was shown passages from the confidential annex in recall. Yeah. One of the issues, even in 2013, which was when the evidence was prepared for the recall case, was that there are other means.
Yes.
Well, I won't go into the detail. There are other means, perfectly lawful means, and which have enormously expanded in their use in the last 10 years, which enable precisely the same outcome to be achieved. In the end, I'm not making any point about that because, as I said at the outset, we're accepting the judgment that has been made. This is a pure virus challenge.
Yeah.
In relation to the speed of response, we have always accepted, as I think I've explained and indeed as the lower courts pointed out, that it would be perfectly permissible to direct the attachment of conditions to the exemption, which mean that it would be unlawful to operate a COMARG unless it was passing CLI. And indeed that appears, I'll show you the evidence in due course, that appears to have been one of the options under consideration in this case. So the suggestion that that is a suboptimal means of response just doesn't, in my submission, have any basis in the evidence in this case.
But this is a virus challenge. I mean, what you're now saying is that you could challenge this direction on grounds that it went further than it should. But that's not the nature of the challenge.
No, it's not.
So I don't quite know how one can really get into this argument. We're not in a position, are we, to determine whether what you propose would be a sufficient response.
Well, my Lord, certainly, in fact, our primary position set out in my written case is that one shouldn't get drawn into attempting to work out what is the best solution or the optimal solution or the most effective solution on the particular facts of this case and then working backwards, because naturally that would be wrong. One can't say, well, we have here a problem with COMARGs in particular, which can't be met by anything other than an individual licensing requirement, and then work backwards to imply the powers into Section 5 to override Section 8, simply because we're told that on the particular facts of this case, nothing else will work.
No, but well, I was just going to say, but that might be the case, either in this case or on different facts.
Yes, I mean, the point I'm making is a completely general one. One can't anticipate what the technological developments may occur, and it's simply the nature of the industry being regulated and the nature of the problems that may be thrown up might be regarded as a reason why Parliament might have intended to enable the minister responsible for national security, or indeed the minister responsible for foreign relations, to be able to respond very quickly.
Could I just add a footnote to that? Because we're construing legislation passed in 2003.
Yeah.
I mean, you've referred us to technological developments many years after that. In construing what Parliament intended in 2003, surely we have, in some sense, to put ourselves back in the position Parliament was then, when anything might happen technologically. Indeed, your answer shows that there's a good deal of toing and froing in terms of technological development. Some things appear to make anonymization easier, and then technological responses to that. And there's a good deal of toing and froing. In 2003, Parliament couldn't be sure that any of those things would have happened and would have met what was a potential problem looking forward from 2003. Sorry to forgive me, but it's to build on what my Lord was saying.
Absolutely. Yes, I'm grateful, my Lord.
My Lord, that's obviously right. The position in 2003 is an important piece of the analysis. However, I wouldn't accept that it is the entirety of it. And the reason for that is, of course, that the Wireless Telegraphy Act 2006 was passed, which reenacted the duty. Indeed, instead of saying shall make regulations exempted, it now says must make regulations exempting in Section 8. So that was reenacted in 2006.
I'm so sorry. How does that help with what we have to decide?
Well, we'll come to it, but because the 2006 Act contains a conflict-resolving provision of its own.
I see. All right, thank you.
And in essence, of course, I see the points that have been made to me about it potentially being desirable to have a confidential direction in a particular case. I see that. The question is whether that has been permitted in a case where one is overriding primary legislation. And the court has my submission that in that regard, one is looking for clear words for a direction to override a statute. Craze on legislation, which is in Core Authorities, Volume 2, Tab 31, EF, electronic page 1665, covers the nature of directions. Mr. Daniel Greenberg, the editor of Craze.
Sorry, give me the reference again, would you mind?
Electronic page 1665. 1665.
Thank you.
Describes directions, as you will see, as quasi-legislation. As we know, they don't have to be laid before Parliament at all. There's no negative resolution. There's no affirmative resolution procedure. Now, the answers that were advanced...
The clear words on the relative or normative position of subordinate legislation. And I was just trying to think in terms more broadly as to what the usual parliamentary procedure is with matters of national security. There's a National Security Committee. But it's not usual for Parliament to be given the details of all the concerns about national security, is it? It usually goes to the committee. It is building on what my Lord Sales said about what the usual procedure is. It's not by legislation or by subordinate legislation. And ordinarily, Parliament has organised itself to deal with national security through a committee, as far as I understand it.
My Lord is, I'm sure, correct, and one thinks of instances where those sorts of concerns are not explained in Parliament for precisely those sorts of reasons. I don't dissent from that. The question in the end that confronts the court here, even having regard to all of those concerns, are we in a situation where, no matter how strong those imperatives may be, Parliament has authorised its own primary legislation to be overridden. And there's no getting away from the fact that that's what would be occurring here. The inconsistency between the duty and the direction is clear, and I know that the court has that point. So here, in my submission, if one is looking at the respective status of a direction, a piece of quasi-legislation vis-à-vis Section 8, subsection 4, it's perfectly clear that one is looking for clear words in another piece of primary legislation to authorise such a piece of quasi-legislation to override. And that presumption can be seen in operation, we say, in the EE limited decision of the Court of Appeal, which I address at paragraphs 57 to 62 of my written case. EE limited was handed down in November 2017, so that's 2 months after the direction in this case was made. We've been to it as a Core Authorities Volume 1, Tab 17, and I shall just get the reference, bearing in mind my Lord Reed's invocation. Electronic page 1143. It was the obverse of the present case. The Secretary of State had made a direction under Section 5 of the Wires Telegraphy Act 2006, and one of the questions was whether that could override duties contained in the Communications Act 2003. And if we go, please, first of all, to paragraph 22, you can see what Section 5 of the Wires Telegraphy Act said. It's at page 1153. The Secretary of State may by order give general or specific directions to Ofcom about the carrying out by them of their radio spectrum functions. And in fact, in this case, under Section 6 of the relevant Act, that was required to be laid before Parliament.
I wonder whether the first sentence of paragraph 22 is significant in this context. Section 3.5 therefore expressly preserves and gives priority to Ofcom's duty to perform its functions in accordance with the community objectives identified in Article 8 of the Framework Directive. Rather goes back to how I was tending to read this judgment, that since Section 3.5 does, if you like, anchor the duty of Ofcom in line with the EU legislation to be an impartial body setting fees. That's a strong indication, one might think, that whatever power of direction the Secretary of State has, he can't override that fundamental feature of the primary legislation.
There is no doubt that that is a feature of the reasoning in this case, and I accept that. My Lord picks up the point about conflict resolution provisions in the legislation, and that is the technique that is used, and as we'll see, it's used in the Wireless Telegraphy Act 2006.
Right. I think I was just focusing on that first sentence of paragraph 22 to see whether you had a reaction to what I've just put to you.
The reaction is that whilst, yes, clearly, the primacy of the Article 8 objectives was a relevant consideration in this case. As we shall see, the Court of Appeal also addressed a pure domestic law argument as to vires and applied the clear words principle.
I may not have made myself entirely clear. What this seems to be saying is Section 3.5, as I understand it, of the domestic legislation is itself saying that priority is given within the legislation to Ofcom's duty to perform its functions in accordance with the community objectives. And that would be a reason why, as a matter of interpretation of domestic legislation, forget mile leasing and all that sort of stuff, one would say that the feature of Ofcom's role to set fees, being the impartial body, as required by EU law, is a fundamental feature of the domestic legislation, therefore not to be overridden.
And that arises...
Well, first of all, is that correct? Have I understood that correctly?
That certainly is a thread of the court's reasoning, and I would not dispute that, my lord, for a moment. But what one will see, if one looks, for instance, in paragraph 23, fourth line, one of the primary issues on this appeal is whether and to what extent the giving of such a direction is capable of displacing the duties imposed on Ofcom by sections 3 and 4 of the Communications Act 2003, which are preserved by section 3, subsection 5, or those imposed directly on Ofcom as an NRA. And the bit on VIRES, well, let me show the court what had been decided below. So if we go to EF, electronic page 1156, and I shall have to take this quickly, but the direction, Article 6, the direction in paragraph 30, you can see the direction was to revise the sums so that they reflect ended up being the critical word, reflect the full market value of the frequencies in those bands. So that's what the Secretary of State told Ofcom to do. Ofcom failed to have regard to the Article 8 considerations in setting the amount of the fees. You can see that from the end of paragraph 31. And Ofcom took the position, you can see in the paper cited at the end of paragraph 32, that because we did not have any discretion to decide whether or not to set licence fees at full market value, since we had been directed by the government to do so. So the issue in the end was whether a Section 5 of the Wireless Telegraphy Act 2006 direction displaced or overrode Ofcom's other duties, and Ofcom took the position that it did. And the judge agreed, so this is electronic page 1158, paragraph 37, last 3 lines. The judge held that those provisions had to be read as subject to the power of the Secretary of State to give a Section 5 direction which has the effect of overriding those duties. And one sees that in paragraph 93 in the citation from the judgment. So the judge had held a Section 5 direction could, and I emphasise this is Section 5 of the Wireless Telegraphy Act 2006, could override duties under the 2003 Act. VIRES starts at paragraph 49 on page 1162. And Lord Panik's submissions for EE can be seen on page 1163 at paragraph 51. Lord Panik for EE submits there's nothing in either the Wireless Telegraphy Act or in the CRF which permits a member state to remove a regulatory function from an NRA. In the United Kingdom, the function of setting licence fees has been delegated to Ofcom by primary legislation. So it's the decision taken in the UK to delegate to Ofcom by primary legislation, and absent clear words, that position cannot be changed by subordinated legislation in the form of the 2010 direction. And then, by the same token, the 2010 direction cannot have been effective to remove from Ofcom the duty imposed on it by Section 4.2 of the Communications Act 2003. So the issue is, can the direction override those duties?
And forgive me, Section 4.2, is that the one that imposes the duty on Ofcom to act in accordance with community requirements?
It is indeed. Paragraph 54. The question therefore arises whether Section 5 authorises the Secretary of State to direct Ofcom in exercising its Section 12 powers to ignore the duties imposed on it by Section 4.2 of Communications Act 2003 and Section 3.5 of the Wireless Telegraphy Act 2006. In my view, it does not. Parliament has imposed those duties on Ofcom, compatibly with Article 8 of the Framework Directive, to be performed in carrying out its radio spectrum functions. It did not obviously contemplate, or in my view authorise, the performance of the Article 8 duty by someone who was not the regulator and who was not carrying out the relevant function to which the duty relates. In the absence of clear words, the Section 4.2 duty is to be treated as non-delegable, and there is nothing in Section 5 of the Wireless Telegraphy Act 2006 which in terms allows the Secretary of State to relieve Ofcom of the statutory duties which Parliament has expressly imposed on it. The language of Section 5 is entirely neutral. So, this case raised squarely an issue as to whether a direction under a power requiring Ofcom to carry out a particular function in accordance with such a direction could override or displace Ofcom's duties under primary legislation, and the answer was that in the absence of clear words, no such power could be inferred. And we see there the clear words principle in operation. Now, the answer to this case that was advanced by my learned friend was this was all about the repatriation issue and Article 8 of the Framework Directive obligations. In my submission, when one looks at the reasoning of the court, particularly paragraph 54, it's concerned with whether Section 5 directions are capable of overriding duties in a domestic statute in primary legislation. And the court adopts the approach, rightly in my submission, that if there's any doubt about that, it's to be resolved against the person claiming the power. It requires clear words. So on that completes my submissions on the first principal point. We say the primary focus is on the words, and insofar as there is any doubt, resolve against the person claiming the power. The second main submission, as the court knows, is that the words of the relevant provisions are against the Secretary of State's case, and I say that whichever approach to interpretation is adopted, whether one is adopting a restrictive or an ordinary approach to interpretation. And we start with the duty under Section 8, subsection 4. It's in Authorities, Volume 1, Tab 9, at electronic page 1038. And we find the duty on page 1039. And this is, just to answer a question that was asked earlier, this is the version of Section 8 that was in force as at the date of Ofcom's decision and the direction. And that's the reason why we've included version 2 of 4 here. Page 1039. If Ofcom are satisfied that the conditions in subsection 5 are satisfied as respects the use of stations or apparatus of a particular description, they must make regulations under subsection 3 exempting the establishment, installation and use of a station or apparatus of that description from subsection 1. And then we see the conditions set out.
And do you accept that 5D is restricted to endangering life in the context of the actual equipment itself?
I accept that, my Lord, is the approach that was taken by Ofcom. The issue is not, to my knowledge, the subject of any previous judicial decision. But I certainly have never made a case that Ofcom had a function of considering national security in this case, and I've been clear about that.
It would be extraordinary
exactly
to use if it's a national security within that.
My Lord, that hasn't been part of my case. It's not. subsection 4 is a clear duty to make regulations. And it's a clear duty as to what the content of those regulations should be. The regulations have to exempt. It can be on conditions, but the regulations have to exempt. And it's common ground that as a result of the conclusions in the COMARG review in July 2017, Ofcom came under that statutory duty. And the issue, of course, is whether it can be overridden. Now, before we even turn to the Communications Act 2003, there is a very strong indication in the Wires Telegraphy Act 2006 itself.
I'm so sorry to sort of hold you up before you go to
My
that.
Lord, no, I quite understand.
I'm still a little bit troubled by this distinction between exemption and exemption on conditions, both as a conceptual matter, but also on the facts of this case, because I thought there was an exemption on conditions in this case. I thought the direction said no license unless A and B.
My Lord, that's not an exemption. Obviously, an exemption is an exemption from the requirement to ask for an individual license at all, in my submission.
But what? All right.
I see. So the first sentence is saying no general exemption.
Yes.
And then the second sentence is beginning a discussion of the terms on which a license could be granted in individual cases.
Exactly, my Lord, yes.
Okay.
The difference would be...
Yeah, and where's the dividing line between the two? So I'm not sure. Does it just come back to the phraseology then of the direction on this submission? That if they put it a little bit differently, everything would be fine? Well, my Lord, I suppose it depends on what one means by a little bit differently in that context. We have never taken issue with the proposition, and the Court of Appeal finds that it would have been perfectly permissible, had Ofcom said we are exempting, for the Secretary of State to say, here are a set of conditions which you must attach to the exemption. Because in that case, Ofcom would still be carrying out its statutory duty to exempt. It would simply be attaching conditions, limitations, restrictions. I should use the language of subsection 3. Terms, provisions and limitations as may be so specified. So that answer does make it sound to me, perhaps I haven't grasped it, that the case then does just turn on the particular formula used in the direction at page 712, that if they had said direct that there shall not be exemption unless particular conditions are shown, that would have been all right?
I don't think so, my Lord, because there still wouldn't be an exemption in my submission.
All right.
The dividing line here is, have there been regulations exempting? That's the duty. And if that duty has been performed, then the Secretary of State has a power to direct Ofcom, in effect, as to how to perform that duty. Because at that point, there has been a carrying out of the duty. But what we do say is it's simply not possible as a matter, even leaving aside presumptions, just approaching this on the most vanilla of approaches to statutory interpretation. It is simply not possible to carry out a duty to make regulations exempting by not making any regulations and not exempting.
This is all a question of construction of section 5.2, isn't it, of the 2003 Act? It's the use of the language in 5.2 that you rely on.
That is one of the
submission.
Yes, there are, however, some very important contextual indications before one even gets there, because if one looks in the Wireless Telegraphy Act 2006 itself, at section 3, and one needs to go into the previous tab for this, it's page 1034. These are a series of duties imposed on Ofcom by section 3. In carrying out their radio spectrum functions, Ofcom must have regard, etc. A whole series of statutory duties, and one then sees in subsection 5 where it appears to Ofcom that a duty under this section conflicts with one or more of their duties under sections 3 to 6 of the Communications Act 2003. Communication must be given to their duties, priority must be given to their duties under those sections. So this statute, where it wishes to give priority to a duty arising under section 5 of the Communications Act 2003, says so. And it would have been the work of a moment to include that provision in relation to the Section 8's duty. But no such provision was made. And as my learned friend observed, the same issue arose under the Communications Act 2003 as enacted. That's section 154, subsection 4 that he showed you earlier. As I say, it would have been very straightforward indeed to include equivalent provision in section 8, or to make subsection 3, subsection 5 wider in its application, but Parliament didn't do so. And that's an important point. It was identified by both the High Court at paragraph 63 and the Court of Appeal at paragraph 56. It's the type of point arising from statutory language which has been influential in many other cases. I've given the Court an extract from Fordham in the Supplemental Authorities electronic page 1921, a helpful list of cases in which the courts have made observations along the lines, it would have been very easy for Parliament to have made this provision, but it didn't. We say that's a very strong indication that the duty under Section 8, just looking at the Wireless Telegraphy Act 2006 itself for the time being, is not subject to such a direction. Nor, when one then turns to the wording of Section 5 of the Communications Act 2003, does it offer support for the notion that it is capable of overriding statutory duties. Section 5, as in force at the time of the direction, is at Core Authorities, Volume 1.
Sorry, again, I'm just pondering on this. Why isn't this provision on page 1034, effectively neutral in the current debate? Because the duties specified which have priority are under sections 3 to 6 of the Communications Act. And if a direction is given under section 5, that creates a duty under section 5.2 on Ofcom. So why doesn't this provision say, well, if you've got one of those, a duty derived in that way, that must be given priority to the duties under those sections? Oh, I see. Sorry.
Yes, that's exactly, my lord.
Right. Yeah. I'm so sorry. I'm being slow here.
Perhaps I'm being even slower. It's the duties under sections 3 to 6. They include the duty under section 5, and it doesn't resolve the issue as to whether it is 3, 4, 5, or 6 that takes priority. And therefore, I agreed with Lord Sales that it doesn't resolve the issue. It begs the question.
Yes, I'm so sorry. When you responded to me, I thought you were making a point that it was the duty. Priority must be given to the duty in this provision, but I had read it right correctly the first time. It's priority to those duties, which include, as my Lord says, the duty under Section 5.2.
My Lord Stevens posits a situation, I think, where duties are relevant under more than one of 3, 4, 5, and 6, if I've correctly understood.
Yes.
And it's true that in that case, one would have to then resolve a further issue as to which of 3, 4, 5, or 6 took priority over the other.
Which is what we're debating. Well, it's not.
No, my Lord. That's why it is important, because, of course, in that case, one would then have to resolve which takes precedence 3, 4, 5, or 6, but we're not in that territory.
Yeah.
These are words that Parliament could have included very straightforwardly in Section 8, but it didn't.
Yeah. So the effect, you say the effect of Section 3.5 is to make clear that the Secretary of State can give a direction under Section 5.2 to disregard any or all of the matters in subsections 1 and 2 of Section 3. So that in the event that the Secretary of State made that direction, Ofcom disregard the matters in subsection 1 of subsection 3, the effect of this is to say that overrides the duty to have regard to those matters. Is that the point you're making?
Yes, it makes clear that a duty arising under Section 5 is capable of taking precedence over those duties.
Over the duty to have regard to these matters?
Indeed.
Yes. Yeah.
And the simple point, obviously, is a matter of ordinary statutory interpretation, where a statute says a particular duty is capable of being overridden by a duty under Section 5, but then there is no such provision in relation to the mandatory words of Section 8.
I see.
The inference is, the strong inference in my submission, is that a Section 5 direction is not capable of overriding.
So does your submission come to this on this provision? Section, whatever it is, subsection 5 here is, if you like, putting two sets of duties in different boxes. There are the duties in subsections 1 to 4, and then there are duties under sections 3 to 6 of the Communications Act. And as a matter of the effect of this provision, it just says the duties under sections 3 to 6 of the Communications Act have priority. But is this right? Your point is Parliament could have used that same formula in Section 5 too?
Or in Section 8?
No, in Section 8.
Section 8.
Right.
Or indeed, that subsection could simply be made wider in its application, so as to embrace the Section 8 duty. I mean, as a matter of drafting, one could achieve it.
So yes, you're not saying it's an effect of this provision. You say Parliament used this model somewhere else and could have used it in the context of Section 5 as against Section 8.
That's right.
Yes, okay.
And that is an issue that obviously in many cases, and I've given the Fordham reference, it has been of very great importance when construing statutory schemes. In the context of necessary implication, it was a decisive issue in the Black case about smoking in prisons.
Yes, thank you.
Can I ask you another question, which it's only just occurred to me in relation to Section 8? We were talking earlier about the possible use of conditions as an alternative to giving a direction. In Section 8, we have the subsection 8.1 lays down the need for a license, and then subsection 2 we needn't worry about, and then subsection 3 enables Ofcom to exempt from subsection 1 the establishment, installation or use of wireless telegraphy stations or apparatus of such classes or descriptions as may be specified, either absolutely or subject to such terms, provisions, and limitations as may be so specified. And then 3A tells us more about the terms, provisions, or limitations that can be imposed, and subsection 3B imposes a requirement that the terms, provisions, etc. be objectively justifiable, non-discriminatory, proportionate, and transparent. Now, we then come to 4, which effectively echoes 3, but without any mention of terms, conditions, or limitations. And there's no equivalent of 3A or 3B. I wonder, in that context, is it plausible to say that an exemption under 4 can be made subject to conditions?
My Lord, yes. And the reason for that is that in subsection 4, the requirement is to make regulations under subsection 3.
Oh, I see. That's the answer to that. Thank you very much. That's fine.
So one has the scheme under the 2006 Act. One then turns to Section 5 of the Communications Act 2003 and asks, where is the support for the notion that this is to be capable of overriding statutory duties? And Section 5, as in force at the time of the direction, is at Core Authorities, Volume 1, electronic, page 1054. This section applies to the following functions of Ofcom. Their functions under Part 2 and their functions under the enactments related to the management of the radio spectrum that are not contained in that part. It shall be the duty of Ofcom to carry out those functions in accordance with such general or specific directions. So it requires Ofcom to carry out the stipulated functions. It makes no reference to overriding statutory duties at all. And the words carry out, if anything, reinforce the underlying duty rather than enabling it to be overridden. If one asks the question identified in public law projects as being relevant in any case of delegation, leave alone Henry VIII powers, whether overriding the Section 8 duty was within the class of action that Parliament must have contemplated when delegating, there is no clue in the language of the statute that that is in contemplation. To the contrary, it speaks of functions in general terms rather than duties. It applies to large swathes of functions amounting to large parts of the entire Act. It uses the words carry out, which reinforce the duty rather than contemplating it being overridden. And as I've already submitted, it is simply not possible as a matter of ordinary language to carry out a duty to make regulations exempting by not making regulations and not exempting. And if there remained any lingering doubt in that regard, which in my submission there should not be, one then needs to look at the provision Parliament made elsewhere in this very same Act as regards directions under the Telecommunications Act 1984. As I observe in my written case at paragraph 16A, the Telecommunications Act 1984 was much amended by the Communications Act 2003 because the whole system of telecommunications licensing under that act was abolished. For that we need to go to page 971. This is in the Communications Act 2003 as enacted. Page 971, section 147. The reason I'm taking the court to this provision is to show that Parliament and the draftsman had the Telecommunications Act 1984 specifically in mind when enacting the Communications Act 2003. One sees that the 1984 Act, significant parts of it were repealed. One then goes to page 1017, and one sees at section 406. Schedule 17 shall have effect. That's minor and consequential amendments. And then the relevant part of Schedule 17 is at page 1023. And you can see item 70, paragraph 70 in the schedule is amendments to section 94 of the Telecommunications Act 1984, directions in the interests of national security. So not only was the Telecommunications Act 1984 in contemplation of Parliament, so too was the specific provision in section 94. Section 94, as amended by the 2003 Act, is at page 1029. Directions in the interest of national security. The Secretary of State may, after consultation with the person to whom this section applies, give to that person such directions of a general character as appear to the Secretary of State to be necessary. That used to be requisite or expedient. It was changed to necessary by the 2003 Act, in the interests of national security or relations with the government of a country or territory outside the United Kingdom. 2 is the content of the direction to do or not do a particular thing. 2A is a requirement of proportionality inserted by the Act. And then 3, a person to whom this section applies shall give effect to any direction given to him by the Secretary of State under this section, notwithstanding any other duty imposed on him by or under Part 1 or Chapter 1 of Part 2 of the Communications Act 2003. And subsection 4, the Secretary of State shall lay before each House of Parliament a copy of every direction given under this section, unless he is of the opinion that disclosure of the direction is against the interests of national security and the such like. So that goes to the publication and confidentiality points that have been raised with me. In this case, a power which does enable statutory duties to be overridden, the requirement is to lay the direction before Parliament, subject only to the exceptional case where that's against the interests of national security, etc. Now again, just as with the point on Section 3, Subsection 5 of the Wireless Telegraphy Act 2006, it would have been the work of a moment for Parliament to have included language such as that in subsection 3 of this provision, which Parliament specifically had in mind when enacting the Communications Act 2003, but it didn't. And the importance of this wording is obvious because it compels Parliament and legislators to confront squarely what they're being asked to authorise. That's where the Public Law Project concerns come in. This provision says to legislators, you are conferring a power which can take precedence over duties contained in primary legislation. And if Parliament authorises that, then so be it. But this is a direction power in the very same regulatory context that was amended by the Communications Act 2003 itself, which includes an explicit duty to give effect to a direction notwithstanding other duties under the Communications Act 2003, and that is provision which was not included in Section 5 of the Communications Act 2003.
So this was the power that was in existence between July 2003 and March 2018, is that right? Version 2.
Let me just check. Yeah, I believe that's correct. Let me just check. I've gone to a different page.
I'm just looking at version 3, and it was brought partially into force on the 21st of December 2020.
Well, my Lord, part of the reason that I stress the points about confronting the costs and debate in Parliament is that this provision, as the Court may be aware, turned out to be politically very controversial, because what had happened is actually in some of the materials that my learned friend exhibits to Mr. Rutherford's witness statement. What had happened was there were a series of directions allowing for the collection of bulk data, which only came to light in a series of proceedings before the Investigatory Powers Tribunal. And in fact, this ended up being replaced with a whole new scheme which set on a statutory footing the collection of that information. It's all set out in Lord Anderson's report, I think, which is in the appendix, part 2, page 262.
The electronic page numbers? The electronic page number?
Yes, electronic page 262. And I won't go through it all, but it explains the background. It's 262 to 264. And then in fact, this doesn't cover the repeal, but there was a note, in fact, before the Court of Appeal that was put in on an agreed basis. Perhaps we can supply it to you, which dealt with the replacement of Section 94. But the point is this: this is a power which generated a measure of controversy, and naturally a power for the government to direct in a way that disapplies other pieces of primary legislation is controversial in terms of the hierarchy of legislative norms. But at least this sort of subsection flags to legislators that that is what they're being asked to authorise.
The Telecommunications Act 1984, I'm not quite sure what that covered, what the subject matter was, but it clearly, as a separate act, remained in force after 2003 and may still be, I don't know. But it's creating a bridge, isn't it, between two separate pieces of legislation. Because, I mean, the question that this poses is whether a direction given under the Telecommunications Act 1984 can be construed as taking precedence over a duty conferred or imposed by a separate separate and subsequent piece of legislation, namely the Communications Act 2003.
True.
I mean, so that raises a rather different issue, which goes back, I think, to the JCCI case and so on, as to whether powers under one piece of legislation can affect, as it were, or override, or whatever word you wish to use, duties imposed under a separate piece of legislation.
I see the point my Lord's putting to me, but of course that it is a separate statute in pari materia in the same regulatory area with an explicit interrelationship in just the same way as the Wireless Telegraphy Act 2006 is in relation to the Communications Act 2003.
I mean, it's very, very clear that the 2003 and 2006 Acts are to be read together. They actually say so in effect, because there's a reference, isn't it, in the section, in the 2006 Act to the Section 5.2 power. I mean, I just don't know whether the 1984 Act or the 2003 Act were statutes in pari materia.
Most of the Telecommunications Act 1984 was repealed. That was the section 147 of the Communications Act 2003 that I showed my Lord earlier. I've summarised the position at paragraph 16A of our written case. There was a whole licensing system for Telecommunications Act 1984 licenses that was abolished in pursuance of the Article 3 obligations in the Authorisation Directive. But the simple point I make is this is another indication of wording that Parliament and the draftsman cannot but have had in mind, given that this provision was actually amended by the Communications Act 2003, which could have been included in the work of a moment in Section 5, but was not.
If I may say so, I always think it's a little bit dangerous relying on arguments that other statutory formulae have been used in other statutes, because ordinarily a parliamentary draftsman will look to achieve what they're trying to achieve according to, if you like to put it this way, a principle of parsimony. They won't necessarily set out and use the same formulae that have been used in other statutory provision if they think that what they have done is sufficient to do the job on its own. And if we're looking in the Communications Act itself, I was just looking at section 132, which again operates on the mechanism of a direction. And so far as I could see, that the formula that the direction, the duty of Ofcom to comply with the direction will override any other duty they may be subject to isn't used, even though compliance with such a direction will conflict, if that's the word you want to use, with other other duties in the Act. So I was really just wondering how much one can get out of the fact that other formulae have been used in other statutes.
I see that point. In relation to Section 132, it's fair to say that Section 132 specifically stipulates the content and effect of the direction that can be given to Ofcom by the Secretary of State. It's far more specific. It's directed specifically to the question of suspending an entitlement to deliver.
I think for the benefit of everyone, I should just give the page number. 958, I think, is where one gets into that. But I was particularly looking at subsection 11, which is on page 959. But sorry, that was just so everyone can follow.
I'm sure I should have done that, my Lord. But the point is this: one really can't compare the specificity of Section 132, which the Court, I think, has on screen now, which relates specifically to suspending the entitlement of a person to deliver an electronic communication service in a particular case, to the generality of Section 5 carry out functions.
Yes, thank you.
And just in relation to the point about statutes, other statutes, and the question in the end is how closely related or otherwise they might be. And I don't have time to go through it, but certainly in black, there was reference to other statutes in the same regulatory area at paragraphs 43 to 44. So when one puts that all together, we say, if one just looks at the words of the Wireless Telegraphy Act 2006 and the Communications Act 2003, there is no support for the idea that the Section 8 duty is capable of being overridden by a Section 5 direction. All the points I've made about the language used in the statutes are ones which struck the Court of Appeal in the Recall Support Services case, which I address at paragraph 63 to 66 of my written case. Given time, I don't think it's going to be possible to take the Court through it. But perhaps we should just turn up the key paragraphs at 56 and 58. It's core authorities to tab 27, and if the court goes please to electronic page 1521. At the bottom of the page, paragraph 56, Lord Justice Richards, the wording of section 5 is however problematic. Section 5.2 provides that if directions are given by the Secretary of State, it is the duty of Ofcom to carry out its relevant functions, which include its duty under section 1AA of the 1949 Act to make exempting regulations in accordance with those directions. That cannot readily be interpreted as requiring Ofcom, if so directed by the Secretary of State, not to carry out a statutory duty otherwise imposed on it. The wording may be contrasted with the terms of section 94, subsection 3 of the Telecommunications Act 1984 quoted above, which require a person to give effect to a direction notwithstanding any other duty imposed on him, and with the terms of section 3, subsection 5 of the 2006 Act, also quoted above, which make clear how a conflict between statutory duties is to be resolved. And my learned friend then showed you the next part of that paragraph. Paragraph 57 answers my Lord Stevens' question this morning as to whether Ofcom could be directed to remove an exemption which had already been granted. And the answer is no. Then the court comes back to the section 5 issue. No relevant direction has ever been issued. None has needed to be issued in the absence of any decision by Ofcom to make exempting regulations. The relationship between section 5 and Ofcom's duty to make exempting regulations has never therefore been put to the test in practice. I have expressed my doubts about the effectiveness of section 5 for the purpose on which the Secretary of State relies on it in these proceedings. And then it's found that the case doesn't ultimately turn on that because the compatibility with EU law, this is in the 6th line, up from the end of the paragraph, does not depend on whether the Secretary of State has the power under domestic law by way of a direction under section 5 to prevent Ofcom from making exempting regulations. So those are the same wording points that I have advanced before this court in relation to carry out section 3, subsection 5, and section 94 of the Telecommunications Act 1984. And for all of the reasons I've submitted, we say on my second point, the wording of the statutes is clearly against my learned friend's case, and the High Court and Court of Appeal were correct so to hold in this case. I should just finally show the court on the wording issue the provisions that I referred to when I answered my Lord Richards' question earlier about provisions permitting the modification of the statute in the Communications Act 2003. And there are examples, usually in relation to penalties. So if we look, for instance, at section 112, yes, electronic page 940. Penalties for contravention of code restrictions. So these are the contraventions of the Electronic Communications Code. Subsection 6 says the amount of a penalty is to be a certain amount. Over the page, on page 941, subsection 10, the Secretary of State may by order amend this section so as to substitute a different penalty, and the requirement is to lay before Parliament. Subsection 11. There are lots of provisions in the statute where an alteration to a significant part of the Act was intended, tend to require that legislation to be placed before Parliament. There's 55, subsection 7, 56, subsection 8, and many others. That brings me finally to the third principal submission I wanted to advance, which is the context and purpose of the Communications Act 2003 does not assist the Secretary of State. In my submission, on a fair reading of the wording that we've just looked at, it is clear that Section 5 does not authorise the Section 8 duty to be overridden. And my learned friend in the end is left asking this court to adopt a strained reading of the words carry out of the Section 8 duty so as to make it subject to other powers that it doesn't mention, of subsection 5 of Section 3 of the Wireless Telegraphy Act 2006 so as to apply it in effect to Section 8.
I understand the Secretary of State to be saying the purpose of the legislation is to have this different aspects being dealt with by different bodies, and the Secretary of State is to deal with national security issues. What do you say the purpose is?
We take no issue with the allocation of responsibilities point.
And then what do you perceive to be the purpose if you're applying that as an approach to statutory interpretation?
The question in the end, my Lord, is what powers has the Secretary of State been given in pursuance of that allocation of functions? So we
as an aid to finding out what the powers of the Secretary of State is, what is the purpose of the legislation?
Well, we know the overall purpose of the legislation, which was to effect a radical reform, as it was put, of telecommunications regulation in the UK, a central purpose being the removal of individual licensing schemes wherever possible. And that is what one gets, of course, from the authorisation directive and from the common regulatory framework. There was a question earlier about whether Section 8 is intended to implement Article 5 of the authorisation directive. That is what the explanatory notes to the Act say, and that's in the Court of Appeal's decision at paragraph 45, which is at electronic page 160. So we know that the purpose overall is to abolish individual licensing schemes wherever possible. My learned friend makes a point that as a matter of competence, the UK remained competent to, in effect, to deviate from that scheme or act within that scheme to protect national security. And again, we take no issue with that. That was ground 1A in the recall support services case in the Court of Appeal. And it was resolved in favour of the Secretary of State that there is competence within Article 5 to keep individual licensing regimes for national security reasons. It was then up to Parliament, against the background of an overall legislative purpose of abolishing individual licensing regimes, to set the terms on which such abolition would take place. And in my submission, it's very difficult to apply presumptions like the presumption against casual change that gets referred to by my learned friend in the context of a statute which was positively intended to effect a radical reform to the entire scheme of legislation in relation to telecommunications in the UK. And that is in the... I mean, this was such a major change that there was a joint committee of the two Houses of Parliament which was convened to scrutinise the draft bill. And you have the report of the joint committee in tab 50, Supplemental Authorities, electronic page 1913. And one sees page 1916, third line in paragraph 1, the government has decided radically to reform the legislative framework for the regulation of electronic communications. So it's a radical reform. The intention is to implement a framework which is to abolish individual licensing regimes. Parliament sets the terms on which those schemes are to be abolished, and it does so by way of the duty in Section 1AA, which is then replaced in due course by Section 8. And Parliament stipulates the conditions on which, if satisfied, there has to be, or the circumstances in which, if satisfied, there has to be an exemption. Subject always to the power of the Secretary of State to direct what the terms, conditions, or limitations attached to that exemption may be. And adopting any ordinary approach to the legislative scheme, that's the effect of it. The Secretary of State may no longer consider that that scheme is sufficient. And if that is right, then the solution is to ask Parliament to alter the scheme. And in this context of looking at the overall purpose, one does have to consider the obverse of my learned friend's point, which is what are the implications if it's correct? This is the point about the breadth of functions which are covered. Section 5 applies to the whole of Part 2 of the 2003 Act. And you saw the long list in the index earlier of functions that are contained in those. It was sections 32 to 197 of the Act as enacted. This is Core Authorities, tab 5, electronic, page 839. This is the index, and one sees an enormous list of statutory provisions.
But you accept that Section 5 applies to all those?
I do.
Except those which impose duties?
It applies to all of the functions, but what it doesn't permit is the overriding of the duties.
I mean, you accept it may have a very broad effect, because no doubt in Part 2 there's a wide variety of discretions and powers as opposed to duties, and I think you accept that Section 5.2 applies to all those.
Yes, it makes quite clear that it applies to the whole of Part 2.
Yes.
The question in the end is, does it enable all of these duties throughout this legislation,
yes,
Part 2, to be overridden?
Yes.
Because there is a danger, one comes back to the point that we were discussing earlier about the danger of construing Section 5 by reference to the circumstances of GSM gateways. There's equally a danger of construing it solely by reference to the interrelationship with Section 8, if one's looking only at what Section 5 itself means. But there are very numerous duties throughout this Part 2. And there's no time to go through them, but they're some of the most important parts of the Act that concern the circumstances in which Ofcom has to set significant market power conditions on communications operators. Section 45, Section 46, one can go through the whole set of powers, but just take SMP conditions, by example, Section 75 onwards, page 909, a duty to apply access-related conditions. Section 76, circumstances in which they give effect to a proposal. Privileged supplier conditions, Section 77 on page 910. Sorry, I gave the wrong reference for the SMP conditions. They are Section 87. Network access, page 918.
With respect, Section 5 is only relevant where there is a question of national security, public health, and so on. I mean, things like Section 78, it's hard to see how they would ever raise those.
Well, or relations with the foreign power, my lord.
Well, maybe. Yeah.
Page 918, the conditions about network access. These are SMP conditions. They're imposed on dominant communications providers. Suppose during a trade negotiation, a foreign power says to the UK, we're perfectly happy to do a deal with you, but the SMP regulation that's been imposed on our national telecommunications champion is really getting in the way here. We want Ofcom to remove the conditions. On my learned friend's case, Section 87, a duty to set those conditions can be disapplied.
So, as I'm now understanding your argument, you're saying that there's a clear divide between duties under the Act and discretions under the Act, and that the Section 5.2 direction applies to discretions but not the duties. Have I understood correctly?
I'm not sure I'd quite put it as discretions.
All right.
But what one cannot do is override the duties. Insofar as there are powers, whether exercised on a discretionary basis or not, then of course directions can be given as to how the functions are carried out. But a power to direct someone as to how to carry out a function, where it's a duty, can't sensibly include a power not.
Well,
yes.
Let me put the
point my Lord has that
put to you that it might be said that a distinction between duties and discretions, and I appreciate you don't put it in quite that way, but yes, what you seem to be saying seems to me to come quite close to that, might be quite difficult to maintain, because you can have discretions where in the circumstances you come to a point where the discretion can only be exercised one way, so it actually conceals within it a duty. And you have duties which are predicated on the exercise of evaluative judgments or discretions, if you like. I mean, I'm looking at Section 77.1, page 910,
yes,
which was one of the ones I think you mentioned, where it said it shall be the duty of Ofcom to secure that privileged supplier conditions containing all such provisions falling within subsection 3 as they consider appropriate are applied to every public communications provider. And so one sees there a duty, but conditioned in particular ways by an assessment, essentially a discretionary assessment by Ofcom. So I'm not quite sure still that, and it's probably my fault, but I would welcome if you could formulate it one more time, where the boundary is between interference or overriding of a duty, as you would put it, and something which does fall within a direction as to how to exercise a function.
Well, my Lord, I think the dividing line in this particular case is very clear, and I should start with that because Section 8, yes, it depends on certain prior assessments by Ofcom under subsection 5, but ultimately the content of the duty is quite clear and specific. My Lord puts to me or raises other powers in the Act where a duty depends on even more open-textured assessments by Ofcom. But nevertheless, the content of the duty, ultimately, is stipulated by the section. So in respect of SMP conditions, it's to set conditions. Now, when one gets into the territory of discretions which rationally could only be exercised in one way, are they then a duty? One might be having an argument either way. But we're not, in my submission, remotely close to that territory here.
Yes, thank you.
Else, Mr. Segan, how are you doing for time?
Not at all badly, my Lord. I should be about another 5 minutes or so, if that's okay, if I can beg your indulgence.
Yes, and if Mr. Beard can be reasonably succinct in his reply, then we can soldier on.
So, my Lord's context and purpose, one is looking at the breadth of the functions covered, the overall purpose of the legislation, which is to remove individual licensing regimes, and it's perfectly consistent with that overall purpose that Parliament should have enacted what it clearly did in Section 8 of the Wireless Telegraphy Act 2006. Which brings me then to the final question, which is this: is it appropriate to adopt a strained interpretation of those provisions because of the national security context, or indeed because of the particular consequences that have arisen or are said would arise in this case? And we address that in paragraphs 47 to 54 of my written case. This is, in the first instance, the point about not putting the cart before the horse, not using the particular facts of GSM gateways to drive the interpretation of Section 5. But in any event, we do say that that whole approach is wrong in principle. Now, I'll come back to that in a moment. Is there a lacuna here? Well, the High Court and the Court of Appeal both held, after careful consideration of the Secretary of State's arguments and evidence, that there was no lacuna. That's paragraphs 80 to 85 of the High Court, 61 to 64 of the Court of Appeal. A scheme is put in place in which exemption is required to take place on such conditions as might be imposed. There's the power under Section 132 to direct cessation in a particular case. And there was here a range of options on the Secretary of State's own evidence. This is Rutherford 1, paragraph 44. It's in the appendix, part 2. It's at electronic page 212. Line 3 of paragraph 44. Ministers were advised of a range of options available to them in relation to COMOGs, including options for giving a direction under Section 5 of the Communications Act 2003. One option was to give a direction which would require Ofcom to restrict the use of COMOGs by permitting them to operate only where the service provider could demonstrate that the caller line identification would pass through the communications network and not impact on accessing communications data. Another was to direct Ofcom to maintain the status quo, i.e. not to remove the licensing regime. And there's no comparative analysis, to answer a question that was asked earlier, in this statement of the respective efficacy of those two options amongst the range of options in this witness statement. And the High Court considered this evidence at paragraphs 31 and 83 and made the finding that it did, that there was no lacuna here. But in any event, we do say none of this is a reason to abandon well-established principles of statutory interpretation in any event. And the Court doesn't need lecturing on the dangers of adopting a strained interpretation of legislation with a view to achieving national security ends. I've set out the exceedingly well-known law on that in paragraph 53C of my written case by reference to what we know happened in Liversidge and how it was subsequently treated. And as we know, it is a very important principle that laws are not strained so as to achieve a particular end which is said by the states to be necessary for national security purposes. And in this case, the reality is, when one looks fairly at the scheme, the Section 8 duty is not liable to being overridden by a Section 5 direction. Any interpretation to the contrary requires a number of provisions to be read in a very strained manner. And however comparatively arcane, technical and arid the context may be in this case, the principle that those provisions should not be given a strained interpretation simply because the Home Secretary says it's necessary for national security reasons is an important one to preserve. So for all of those reasons, we respectfully submit that the High Court and the Court of Appeal were absolutely right to find that this direction was ultra vires and that the appeal to this court should be dismissed. Unless I can assist further, my lords, those are my submissions.
Thank you very much, Mr. Segan. Mr. Beard.
I'll be very brief, taking Mr. Segan's 3 points. His principal point was about the use of the clear words rule. Obviously, we only get there on the basis of his assumption that Section 8.4 creates an absolute duty, because if the legislative scheme is in fact saying that duty may be qualified by the terms of any direction, then even on his account there is no overriding or modification. As it is, his submissions really, on the clear words principles, didn't engage with the key provisions in O. In particular, it didn't engage with Lord Hodges' observations in paragraph 43, which set out the admonition that one needs to constrain the clear words principle. That is particularly important when Lord Hodge himself, specifically in paragraph 40, looked at those issues to do with 2 statutes, the second of which permits subordinate legislation which may affect, modify, amend, or repeal parts of the first legislation by subordinate terms, and his analysis in paragraphs 40 onwards is concerned with that as well. I dealt with the other Henry VIII type cases briefly in opening, but without wanting to lapse into Lord Staines's broad statement that in law context is everything, it is clearly critical as soon as we are in the territory of asking ourselves what assumptions or presumptions should apply. And in this case, what we have are no fundamental rights at issue. We have very fundamental public interests that actually underpin fundamental rights. We have the 2 provisions we're concerned with within the same legislative scheme and subject to extremely clear limitations. The 4 heads are clear limitations. Necessity and proportionality are clear limitations. And as for the EE case, I won't repeat my submissions on that. It offers no assistance. It doesn't provide useful reasoning in relation to the extent of the clear words principle, and for the reasons that were canvassed in submissions, is in an entirely different context. When we come to the wording, we say the term carrying out can be read broadly. It's a portfolio term being used in a general provision which can apply to a whole range of functions that are set out in the legislation, and is therefore what might be called some sort of portfolio term or general term that doesn't involve a strained reading in order for it to be applied in the context of Section 5 directions related to Section 8 licensing and exemption under the WTA. Yes, it may be said to be parsimonious drafting. It is rarely a criticism of drafting that it is parsimonious, but one can see that other words could have been used. That does not, however, alter the context or purpose of Section 5. As to the other models that Mr. Segan called upon, Section 154.4 and Section 3.5 of the Communications Act, they referred to giving priority to duties under Sections 3 to 6. As I said in opening, that range of duties covers a whole variety of types of duty, including many have regard to duties, and is a general position being put forward. It doesn't undermine the force of the directions being referred to in Section 5. Ironically, one way of dealing with Mr. Segan's suggestion would actually to have been taken out Section 5 from those references rather than including other model drafting in the Act. As to Section 94 of the Telecommunications Act, different Act, point has already been picked up during the course of submissions, but I would just point out a couple of other things about it, because it does involve slightly different processes. The Section 94 directions are not only directed to Ofcom. They can be directed to third parties. That is a fundamental difference. Indeed, it was that which created the litigation and concern in relation to rights more generally. And therefore, you are dealing with a different provision, dealing with fundamentally different types of direction. But as I say, more generally, there is a grave danger in trying to pick out these model pieces of drafting and say, that's what you must have done. The one case that Mr. Segan referred to where that was done and referred to was Black. Black, of course, was a case where the clear words principle plainly applied because it was to do with the question of whether or not the Crown was bound by a statute, and there's no issue there. So in those circumstances, carrying out some of these comparators to work out what clear words constitute may be relevant. But it doesn't assist Mr. Segan. Then in relation to his third points about the purpose, well, with respect to Mr. Segan, he did not give a proper answer to the question of what is the purpose of Section 5. He said the legislative scheme is intended to implement European law. True. The legislative scheme moves towards the European law's approach to general authorisations. Also true. But the EU law left open the situation of a member state with particular public interest concerns being able to require licensing. And that is precisely what Section 5 does. And he has no answer to the rhetorical question as to why it is that a reasonable legislator would have removed the power from the Secretary of State to protect those public interests by enabling licensing regimes in its implementation of the European scheme and in the enactment of the Communications Act 2003. He has no answer to the question of why it is that a reasonable legislator wouldn't permit maintenance of those sorts of licensing conditions. And I won't refer further to the issues to do with lacuna, but I do note that those matters were dealt with by Mrs. Justice Rose, as she then was, where she found that licensing was proportionate. That means it was necessary and other alternatives were not sufficient. That is only in relation to this case, these situations. It is only an example, but it shows that the prior licensing requirement, in order to protect fundamental public interests, is an important part of this legislation, and Parliament, we say, recognised that. Unless I can assist the Court further, those are our submissions.
Thank you very much, Mr. Beard. Well, we're very grateful to both counsel for very clear and full submissions on a tricky point of statutory interpretation. We'll let you have our judgment as soon as we can.
Great.